Let's talk about family court attorneys and guardian ad litems. Here we go. Family law attorneys are the only profession where the business model requires your family to stay broken. The conflict is the product. That's the core con. A family court attorney bills by the hour to resolve a conflict that pays them by the hour. That's the whole scam in one sentence. It's like hiring a firefighter who's paid per flame. Every other professional you hire wants to finish the job. Your lawyer's mortgage depends on your divorce having a sequel and a prequel and a cinematic universe. We need to file a motion means my kid's tuition is due. Every hearing on your case is a fundraiser you're not invited to enjoy, but you're invited to pay for. Divorce attorneys don't sell resolution. They sell escalation with paperwork. You come in wanting to split the dishes and you leave in year 3 of discovery over a crock pot. The retainer for a family law attorney is the only bill in America where you pay $10,000 up front to find out what the bills are actually going to be. By the way, your attorney and your ex's attorney are friends, not metaphorically. They had lunch Tuesday. They golf. They refer each other cases. You're not in a war. You're in a pro wrestling match. And you're the only one who doesn't know it's all rigged. Two family lawyers screaming at each other in court. They then walk out and go, "Hey, you want to grab lunch?" Your family's destruction is their coworker small talk. You're not the client. You're the shift that they happen to be on. They call it professional courtesy, the mutual agreement to never make the other side actually lose because next month the roles reverse. It's a cartel with continuing education credits. The most honest moment in family court is watching opposing counsel agree quickly to a continuance, like in 4 seconds flat. They can't agree the sky is blue when you're paying for the argument, but on their calendars, hey, instant harmony, it keeps the case going. They bill in 6-minute increments. Family lawyers bill in 6-minute increments, which means a thanks, got it email costs you $75. Your lawyer bills you to read the email, bills you to think about the email, bills you to forward the email to the paralegal. Then the paralegal bills you to read it. One email has 4 or 5 charges. The post office moves letters for 73 cents or so. Your lawyer charges $400 to receive one. Every filthy move in family court is committed under the banner best interest of the child. It's the thoughts and prayers of litigation. No attorney has ever filed a motion titled, "In the Best Interest of My Boat." Two lawyers will spend $200,000 of the college fund arguing about the child's best interest. The child's best interest was the $200,000 they just spent. They fight for 18 months over custody percentages like it's a corporate merger. We propose 60-40. Counteroffer, 55-45 with alternating Thanksgivings. Congratulations. You've just securitized a 9-year-old. The kid needs braces, therapies, and a college fund. What the kid got was 2 attorneys with better cars than either parent and a guardian ad litem who met them once or twice. The guardian ad litem is appointed to be the child's voice, but they meet the child for about 30 to 40 minutes. They bill 12 hours. They recommend what the judge was already leaning. That's not an advocate. That's a weather vane with an invoice. Custody evaluators. $15,000 for a stranger with a clipboard, watch you make lunch, and write a novel about your personality. It's like a Yelp review of your parenting, except it's binding, and the reviewer has never returned to check if the restaurant actually improved. The evaluation asks about your childhood, your ex's accusation, your Facebook, everything except the question you paid to answer. It's a colonoscopy that never reaches a diagnosis, but does bill like surgery and contains a lot of shit. Family court attorneys fear judges more than they love clients. We've already covered that math, but here's the punchline. In family court, there's no jury, none. The judge is the whole audience. So your lawyer isn't an advocate. He's auditioning as an opening act who wants to get booked again. They're not performing for you. They're performing for the guy with the robe on and the calendar. Clients ask me sometimes, they say, why won't my lawyer actually advocate for my ADA rights? Why won't they say what you say? Because I can leave. Your lawyer lives there. You don't criticize the chef when you eat at the restaurant every day. They'll spit in your food. I'm DoorDash. I don't care about the chef's feelings. I read the health code, which is the ADA, out loud. The dirtiest secret is that a family lawyer who genuinely wins fast loses twice. They lose the fee and they lose the referral because the machine only feeds lawyers who help feed the machine. The best family attorney in town by reputation is just the one with the best relationship with the bench. That's not a legal skill, that's a loyalty program. People ask me the difference between me as an ADA advocate and a family court attorney. Simple. A family court attorney looks at a broken family and sees a revenue stream. I see a broken family and see a violation of the ADA or numerous violations with statutes attached. They bill you to manage your problem. I show up to end it. Guardian ad litems, that's the most perfect scam in the building because it's invisible. A lawyer is appointed to represent an abstraction, best interests, instead of a person, which means their actual client is a concept. Concepts can't fire you. Guardian ad litem represents the best interest of the child, not the child. Let me say that again. The guardian ad litem represents the best interests of the child and not the child. The kid has a lawyer who is explicitly not their lawyer. You don't believe me? Check it out. It's the only arrangement in law where a kid's lawyer is licensed to overrule them. Imagine hiring an attorney who announces, I'll be arguing against your wishes for your own good, and you're paying. Actually, your parents are paying. Every other human in that courtroom gets an advocate for what they want. Mom's lawyer should argue mom's position. Dad's lawyer should argue dad's. The child gets a lawyer for what a stranger guesses they should want. The one person the case is about, the child, is the one person with no actual voice in it. We gave the kid a ventriloquist and called it representation. If the child says, I want to see my dad or my mom, and the guardian ad litem disagrees, guardian ad litem reports wins. A 12-year-old's testimony about their own life is outweighed by a 40-minute impression formed by a stranger who got their parking ticket validated. We trust that kid to pick their own classes, their own friends, eventually their own doctors, but their own father? Sorry, sweetie. The concept has counsel. Best interests is the legal system's horoscope, vague enough to be unfalsifiable, flexible enough to justify anything, and delivered with total confidence by someone you paid to tell you what was going to happen anyway. Here's the tale that is totally arbitrary. The best interests of the child have a suspicious habit of aligning with the convenience of the court. Best interest of the child almost never require the judge to reverse themselves, question the first accusation, or hold an extra hearing. It's miraculous how the child's welfare always points downhill. The guardian ad litem does an investigation. They do one home visit per parent. Sometimes they even skip that. A school email they'll read, maybe chat with a kid over crackers. Then they author a report that determines a human being's childhood. I've seen more due diligence used on a Camry. Carfax checks more sources than a guardian ad litem. A guardian ad litem interviews a child for under an hour, files a report on who that child is. Netflix needs 10 episodes to profile a stranger. This person does it in the time it takes to microwave 2 Hot Pockets, and their conclusion is binding. The methodology is airtight. Whoever accused first wins the framing. The guardian ad litem doesn't investigate the accusation. They investigate around it, the way a decorator works around a load-bearing wall. The first allegation isn't evidence to them. It's basic architecture. One accusation, no finding, no conviction, no investigation, and a fit parent is yanked like a fire alarm got pulled. And here's the atrocity dressed as protection. The system calls that erring on the side of caution. Caution for who? The kid just lost a parent overnight based on an unverified sentence, and the guardian ad litem's job, the entire alleged job, was to check. They didn't check. They chose the side that required no courage, and they billed you for the ride. Then comes the second trauma, the one nobody invoices for. The child, already gutted, learns the courtroom's real rule. Agree with the file or watch the adults frown. So the kid toes the line, and the guardian ad litem writes, The child is adjusting well. And the report enters the record as proof that the removal worked. That's not child advocacy. That's Stockholm syndrome with a billing code. They wound the kid and then cite the kid's silence as the desired outcome measure. A guardian ad litem who sides with the first accusation without investigation isn't a guardian ad litem. They're a guardian ad lazy. The Latin was right there the whole time. Who appoints the guardian ad litem? The judge. Who reappoints the guardian ad litem to the next 40 cases? The judge. Now, pop quiz. Whose best interest does the guardian ad litem actually serve? The guardian ad litem is the judge's weather vane, but it's worse. They're also the judge's alibi. The report exists so that the ruling has a citation. The judge decides, the guardian ad litem finds, the order says, based on the guardian ad litem's thorough investigation, the court sourcing itself and calling it verification. A guardian ad litem contradicting the judge's lien is a guardian ad litem choosing disappointment over the next 100. Guess how often that math resolves in favor of the child? The child can't reappoint anybody. Only the judge does that. The child is the only participant with no repeat business to offer in a building that runs entirely on repeat business. And the fees? Parents are ordered to split the guardian ad litem's bill, hundreds an hour, for the privilege of being investigated by someone auditioning for the judge. It's a product you're court ordered to buy from a vendor you didn't choose, whose deliverable is a document about why you should see your kid less or not at all. A guardian ad litem is what happens when you ask, what if the child had a lawyer? And the system says, hey, I got a better idea. What if only the file has a lawyer? The guardian ad litem's report said the child's best interests were served. The child was not consulted. The interests were not defined. The service cost 11 grand. Other than that, though, it's airtight. The best interest of the child is the only legal standard whose definition changes by courtroom, whose expert changes by appointment, and whose outcome changes by nothing, because it was always going to be whatever kept the calendar moving. Premium air, green cap, same nitrogen. The guardian ad litem is the only actor in the building who literally cannot be cross-examined by their own client. Then I walk in and I give them a letter saying that the child has a disability and the child is not receiving equal access to their services. That's a problem. Guardian ad litems are usually never challenged. Think about that ecosystem. The parents fear them. The lawyers court them. The judge protects them, and their client is 9. The guardian ad litem has spent 15 years being the most agreed with person in the court. Their professional muscles for handling disagreement have fully atrophied. They're a house cat who's never seen a coyote. The ADA is the coyote with the statute. Everyone in family court has a boss. The lawyers answer to clients, the judge answers to appeals theoretically, and the guardian ad litem answers to a concept. You can't depose a concept, which means for their entire career, the best interest of the child has meant whatever I say, unchallenged. When an ADA advocate comes in representing the actual child's disability needs, suddenly the concept has competition. The look on their face when they realize that the child, the prop, the file, has an advocate. It's a look of a puppeteer watching the puppet stand up. So here's how it works. The child already has one disability. That's a legal disability called the disability of minority or being a minor. Trauma adds another disability. A trauma response substantially impairs major life activities, and that's not poetry. That's the ADA statutory definition. So now this kid isn't a file. This kid is now a protected class. And everything the court's been doing to manage the child, expecting the child to perform under composure, punishing the symptoms as attitude, running proceedings that the child's condition can't access, stopped being case management, and now it's become discrimination with a docket number. Title II covers the court itself, public entity, no exemption for robes. It also covers what the court delegates, such as guardian ad litem services. Title III covers the guardian ad litem's own office. There are public accommodations, same category as a dentist or a bowling alley. All of their goods and services have to be ADA accessible, including those that are purportedly for the best interest of the child. They've spent their entire career as an officer of the court being accustomed to being untouchable. I write them a letter explaining that they're also the office of a lawyer under Title III and a delegate of the court under Title II. When you can watch their entire self-concept reorganize in real time, that's a real treat. It's the legal equivalent of showing someone a photograph of their own house. The statute is the threat. Here's the magic part. What do they do with my letter? They don't answer it. They don't rebut it. They run to the judge, the supposed child's advocate, sprinting to the bench like a kid who found a spider in their lunchbox. Your Honor, he sent me this. Running to the judge with my letter is the most honest thing a guardian ad litem ever does because it confesses the whole organizational chart in one motion. She didn't run to her client. She didn't run to the law. They ran to the source of appointments, the judge. In one panicked hallway sprint, they diagram exactly whose interests they represent, and it's the first accurate move of their career. And then the beautiful part, the judge looks at the letter, does the math, and removes them, not to protect the child, to protect the court's image and reflection. They thought they were showing the judge a threat. What they were showing the judge with my letter is a liability. They walk into chambers as the court's alibi, and they're ushered out as its exposure. That's a walk of shame. A lawyer could never do this and doesn't do it. A lawyer who runs a guardian ad litem off of a case would never eat lunch in that county again. But I'm not in the cartel. I don't need the referrals, their appointments, or what Thai restaurant they go to. The whole immune system of that building is designed to attack anyone with something to lose. I'm a pathogen with no receptors. There's nothing to grab. It's the ADA. Guardian ad litems represent the best interests of the child right up until the child gets actual representation of their disabilities. Then they represent the best interests of their exit. You want to know the difference between me and a guardian ad litem? When the child has a disability and a need under a disability, I write it out, I document it, and I present it to the guardian ad litem and let them know they're not given equal access. When the child speaks to a guardian ad litem, they write down what they think the judge will like. The guardian ad litem's entire career has been unchallengeable. And then the ADA comes in, and it turns out that the best interest of the child fits on just a few pages when you actually mean it. Concerning the trauma, the system actually creates the trauma, the silver bullet accusation, the yanked parent, toe the line pressure. Then the trauma becomes a disability, and the disability becomes a legal weapon that removes their immunity from the guardian ad litem. The court actually forges the sword that cuts it. They manufactured the very condition that federal law now makes them answer for. That's not just satisfying, it's epic.